Welcome everybody to today's micro lecture on EU law. As you can see, this micro lecture is structured in the following way. We will first talk about the hierarchy of EU law. We'll then have a look at decision making in the EU, and we will address the question of the so-called vertical distribution of competences, that it is to say, who is entitled to make new legislation, the EU or the member states. We have these guiding questions, which already by now should make you reflect on these questions, and they will be answered by the end of today's lecture. So, first of all, which hierarchy can we find in EU law? Which interests do different EU institutions represent? When can they adopt EU directives and EU regulations? And how can you be affected by EU directives or EU regulations? You might remember from the micro lecture on law those examples of law where we have addressed the question whether to qualify those examples of law. And we have then looked at those examples from the perspective of the hierarchy of law. And we will now focus on what you can see on the top left side. So EU law, and it's very important to remember that EU law has supremacy over national law, but if we look into EU law, we can see that we have EU primary law, which is enacted by all member states, and still at the level of EU law, but below EU primary law, we have what we call EU secondary law, which is enacted by EU institutions. So the e-commerce directive, which has been adopted by the European Parliament and the Council of Ministers. Or another example, which can rather be seen as an exception, the product liability directive, which only has been enacted by the Council. So if we look a little bit more into the details of the hierarchy of EU law, we can see examples of what we call EU primary law. So the Treaty on the European Union, the Treaty on the Functioning of the European Union, TEU and TFEU. Also accession treaties. So if new member states join the EU, that's also primary law. Also those revision treaties, so the Amsterdam Treaty, the Maastricht Treaty, the Lisbon Treaty or the Nice Treaty, those are all part of EU primary law, accession and revision treaties. Also very important, the Charter of Fundamental Rights of the European Union, that is also qualified as primary law. If we look at EU secondary law, we have different examples. You can see that two are highlighted, EU regulations and EU directives, which are, let's say, the most important examples. You also have the definition of a decision, of a recommendation, but we will focus on EU directives and EU regulations. So, what does it mean, an EU regulation? As you can see here, and that's the information provided at EU primary law, a regulation shall have general application. It shall be binding in its entirety and directly applicable in all member states. So if you consider the legal effects of a national law, which is directly binding on you, can be rights or obligations. In case of an EU regulation, adopted one level above, it's the very same. So also the regulation is directly applicable to you. It can be binding on you. It can be advantages, rights, or disadvantages, obligations. If we move on to the definition of a directive, as you can see, it's only binding as to the result to be achieved upon each member state to which it is addressed, but, now that's the difference, it shall leave to the national authorities the choice of form and methods. So, as you can see, the directive is addressed to the member states, and then the member states need to implement it into national law. In other terms, as long as it's not implemented, it's not binding on you. So if we add to this slide who has the power to make new primary, secondary law or to change existing primary or secondary law, as you can see, it's all member states together. So it's not the EU institutions, that's very important. It's the member states and, I would say most important, all member states together, they can change primary law. So that means if only one of them is against it, then primary law cannot be changed. For secondary law, it's not the member states, but the EU institutions. And here we have a proposal of the European Commission, but as it's mentioned here, it needs to be adopted by the European Parliament and by the Council of Ministers. So again, primary law, it's all member states together. For secondary EU law, we have a proposal of the European Commission. So the picture on the right-hand side, the European Commission represents the interests of the whole EU. Then in the middle, we have a picture from the Council of Ministers. That's the institution which represents the interests of the member states. And here on the left-hand side, we have the European Parliament. That is the one institution that represents the interests of the citizens because it is elected by EU citizens. So a proposal of the Commission which needs to be adopted by European Parliament and Council of Ministers. So we don't really need to talk about the decision-making of EU primary law. So in this slide, we talk about the decision-making concerning EU secondary law. And you can see the process in a very simplified way. So at the very bottom, on the top of the slide, we have the Commission trying to gather some expertise, doing consultations, trying to answer the question, is there a need for a new EU directive or regulation? And if yes, what should it look like? So gathering expertise from key stakeholders, but also from the society at large via consultations. Then the Commission makes an official proposal, and this proposal then starts the whole legislative procedure, which here is displayed in a very simplified way. Then Parliament and Council need to decide together. So what the example that we have seen earlier, the Product Liability Directive, that is an exception because it was only adopted by the Council. But as a rule of thumb, nowadays, the majority of all topics need to be adopted by both Parliament and Council of Ministers. Then law, as in case of the directives, needs to be implemented, as we have seen it before, and the Commission, representing the interests of the whole EU, acting as a guardian of the treaties, is in charge of checking that EU law is correctly applied, and eventually they could bring, for instance, a member state to the Court of Justice if a member state fails to correctly apply EU law. Just to repeat again, the different interests, and that's very important, which are represented by those three EU institutions involved in the decision-making process, the European Commission, European Parliament and Council of Ministers. So those different interests are also part of those two videos which provide further information on this decision-making process between especially the Council of Ministers and the European Parliament. Now, one very important question is the following. If we talk about law, in this case EU secondary law, who is entitled, now talking about a vertical perspective, who is entitled to make new law? Is it the EU or the member states or both of them together? So we call that the vertical distribution of competences, where we have exclusive EU competences, so-called shared competences, or the last category, competences of the member states, where the EU can only support, coordinate or supplement the member states' competences. So if we look into this vertical distribution of competences, we can see that questions of the customs union, questions of the euro, so the single currency, at least for those countries who have adopted the euro, and other questions, the common commercial policy, those are all questions where we have an exclusive EU competence. That means, for instance, that Austria could not reintroduce the shilling, or Germany not the Deutsche Mark, because that's not an EU competence anymore. So that's a competence which has been completely shifted to the EU level, so member states cannot regulate in this field anymore. First category. Second category, shared competences. So here we have both the EU and the member states which can pass legislation in those fields. So what does that mean for you? If you search for the relevant legislation, let's say, for instance, in the field of consumer protection, you would have to do the research both at the EU level, in the EU legal database, EULEX, and at the national level, in the national legal database, to find all the relevant applicable legislation in that field. As you can see, that's a long list covering consumer protection, the internal market, social policy, transport, and so on and so forth. Last category, so that's basically still the competence of the member states, for instance, to decide how to organize their health systems, how to finance it, who should have health coverage and all those questions, how to provide health care to citizens. So that's basically national competence. The EU can only support the member states in their competences. It can only coordinate the member states, or it can only supplement to these competences of the member states. So one example would be if students do an Erasmus exchange. You could say kind of a supplementary function would be that Erasmus students studying abroad get a financial payment, maybe not only from their national ministry, but also from the European Union. So that's, from the EU's perspective, so to say, the weakest form of competences. So now you know the hierarchy that we can find in EU law. That's EU primary law on top, enacted by all member states, the EU treaties, the TEU, the TFEU, the Charter of Fundamental Rights. Those are all examples of EU primary law. And as you know, if you want to change just one word in those documents, all member states, important, all of them have to agree. If a single one of them does not agree, there can be no changes. Below we find EU secondary law, EU regulations, and EU directives. Regulations are directly applicable in member states. Directives, as we have seen, need to be implemented into national law. So member states need to get active so that the content is directly binding or applicable on citizens and companies. Which interest do those different institutions represent? That's very important. So instead of having to learn a lot of details about those institutions, if you know that the European Commission, the EU commissioners, that they represent the interests of the whole EU, that's very important to understand a lot of current examples. The European Parliament is always acting in the interests of the citizens, because it's also elected by the citizens. And the Council of Ministers, that's one institution representing the interests of the member states. When can the EU adopt EU directives and EU regulations? As we have seen, we have to look on those 3 slides in order to find out whether it's an exclusive EU competence, a shared competence, or basically a competence of the member states, where you can only support, coordinate, or supplement. What is also very important, if we do not talk about primary law, but about secondary law, we first always need a proposal of the European Commission, which then needs to be adopted both by the European Parliament and the Council of Ministers. And as we have already seen, you are affected by different types of EU secondary law in different ways. because if an EU regulation is adopted at EU level, it's directly binding on you, whereas we have seen that EU directives are addressed first at the member states, and they then, in a next step, need to implement those directives into national law. So hopefully now you know more about EU law.